Hello, this is Matthew Kane, Family Law Facilitator for Siskiyou County Superior Court. This brief tutorial is for the petition for dissolution of marriage or domestic partnership. This is also used for the petition for legal separation or annulment of marriage or domestic partnership. I will be covering the importance of this form and how to fill it out in this video. This is the Judicial Council form number FL-100 in case you like to refer to these that way. So you'll start in the upper left-hand box filling in your name. Don't worry about the firm name. That is for an attorney. If you have an attorney, they will be filling that out for you. You will fill out your street address and the city where you live, your state, your zip code. It's helpful to the clerks to put in a telephone number and an email address. Don't worry about the attorney for box. Again, if you have an attorney, he or she will write that in there. I am preparing this form for Siskiyou County, California. However, this form applies statewide. The reason why that's important is because you have to put in the address and the name of the court where you are filing your papers. If you are in Siskiyou County, then the information is Siskiyou, the street address for the court, the mailing address, city and zip code is Wairika 96097, and the branch for the filing is family/civil. If you live somewhere else, do an internet search or even in the phone book to get the name and address of the courthouse closest to you. Some of the bigger counties in terms of population may have multiple courts, and which court you file in may depend on your zip code or which part of the county you live in. So just do a little bit of research to make sure you are filing in the correct place. Okay, scrolling down a little bit here. The petitioner is you. This is the person filing this form. Um, you are starting the action by filing this petition for the entire rest of this case. If you have children, that means until your children are grown, you will always be the petitioner and the respondent. So the respondent is your ex or soon to be ex. This is the person that you are divorcing or separating from or getting an annulment from. Um, this person will always be the respondent. So next box down, you have some choices here. If you are married, then whatever choice you make, just mark the box for marriage. If you are in a domestic partnership, you will mark the box for domestic partnership. If you are seeking a divorce, you'll mark the box for divorce. Know that in California, you have to be in the county where you are filing for divorce for at least 6 months and for the 3 months right before you file. It even says so right here under paragraph 2, at least 6 months and the last 3 months immediately before filing. If you are not asking for a divorce but merely asking for a legal separation, that time doesn't apply. Okay, so I can't tell you if you should file for divorce or separation. That's a choice you have to make. There are lots of resources you can find on the internet explaining the benefits of one or the other. I can tell you that if you have chosen whether you're going to file for dissolution or separation, that this is the form to use and that those are the boxes to check. I can also tell you that if you are seeking an annulment, you will check that box. There will be more proof necessary. There are only a limited number of reasons the court will grant an annulment. I will go over those in just a little bit when we get to the next page of this form. Okay, let's go down a little bit here. So legal relationship, you have to tell the court whether you are currently married or whether you are in a domestic partnership. If you're in a domestic partnership, you have to choose whether you are in a partnership that was established in California, which would be B, or if you are in a domestic partnership that was not established in California. Maybe you're from another state and you had your domestic partnership there. You just need to let the court know if that's the situation by checking the correct box. I talked about the residency requirements. So one of you, if you are getting divorced, has to have lived here for 6 months and the 3 months before. So if that is you, then click this box. If that is the person you are divorcing or separating from, then click the box next to respondent. If it is both of you, then check both boxes. Again, scroll down to B if you're in a domestic partnership and it was established in California. You mark box B. If box C applies to you, then check that box. Down to paragraph number 3. For marriage, check box A. Write in the date of marriage. So just for example's sake, I'll put in 1/1/2000. Date of separation is the date that you believed the marriage was broken beyond repair. This could be the day you moved out. Maybe you haven't moved out, but you felt this way for some time. You have to pick a specific date for the separation. You can kind of estimate what date it was. If you think you were separated, back 2 or 3 months, that's fine. You just do need to put in a specific date. So just for example's sake, I'll put in 1/1/2018. Okay, so then it asks you to calculate how many years. So in this case, that would be 18 years. And how many months? In this case, that would be 0 months. Because the marriage and the separation were January 1st. If you are in a domestic partnership, go ahead and do the same for paragraph B, asking for the registration date, the separation, and the length of the domestic partnership. Scrolling down to paragraph number 4, if you and the person you are divorcing have children that are under 18, so that they are minors, and they are your common children. For example, they were born from you and the person that you're divorcing. Those children will go here. If these are your children that you had before this current marriage, then those children aren't listed here. This is only for children of the marriage. If there are no children, it's easy, just mark box A. If there are children, then mark box B, write in oldest child's name and birthday, so maybe, and then if there's a second child, then write in and birthday and age and gender of the children. If there are more than 4 children, mark the box here, attach a sheet of paper and write the same exact information, but just for the additional children. Also, if you are expecting and your child hasn't been born yet, you can mark box 2 over here and include that information. Okay, if there are children the court is going to have to make decisions regarding custody, or at least have the ability to make decisions regarding custody. You will have to fill out this form. There will be another tutorial for that form specifically, but you will need to fill that out, or the clerks will reject your filing until it is done. Okay, so on to paragraph 5, the legal grounds. So if we're having a divorce or a separation, are both under subparagraph A here. So let's just mark for divorce. So your grounds are either irreconcilable differences, which basically is a catch-all for any explanation for why you want a divorce, is irreconcilable differences. You don't have to prove that the other person is bad or has cheated or done anything wrong. You just have to mark irreconcilable differences. You can mark legal incapacity to make decisions. That's fine, that's a choice. If that applies, you will need some proof from doctors before the divorce can be finalized. Given the broad scope of the box for irreconcilable differences, I would not probably mark box 2 unless you know exactly why you are doing that and you have a specific reason to do it. Otherwise, it's just very simple to mark the irreconcilable differences. Okay, I said just a little bit ago that there are only a few reasons why a court will grant an annulment. So let's look at what those are. So under box B, if your marriage is one of incest, which means you're married to somebody who's too closely related to you, or if it is a matter of bigamy, which means that the person that you are married to is already married to somebody else, or that you are already married to somebody else, then those marriages are void, which means that in the eyes of the law, they never happened. And an annulment is proper to undo those, to put the parties to a place where they are no longer thinking that they are married. Okay, so that's void, which just means that no matter what, you can never in California have a marriage out of incest or out of bigamy. They are just considered not legal. Okay, under box C is an annulment of a voidable marriage, and that just means that it's a marriage that can be annulled if one party asks for it, but if nobody asks for an annulment, then it's not going to be annulled. So what are the reasons for a voidable marriage? Age at the time of marriage. It's possible that if you or the person you were divorcing were underage and you did not have the consent of your parents or consent of the court, then either of you can ask for an annulment based on being underage, one of you or both of you being underage at the time of the marriage. Prior existing marriage, this is similar to bigamy in that one or the other of you might have had a prior marriage that wasn't completely dissolved or undone before the marriage. Unsound mind, this is somebody who lacks the capacity to enter into a contract or enter into an agreement. This will require proof of from a medical doctor explaining the condition of the other person and why it is that their mind was unsound at the time of the marriage. Your other choices are fraud. This would be, for example, if you got tricked into getting married. Force, if somebody held you at gunpoint and told you to say I do, and so you did because you were being held at gunpoint, that would be force. Physical incapacity, Again, this is one like the legal incapacity. If you are marking physical incapacity, it's because you have a specific reason. And we will move on to child custody and visitation. If there are no children between you and the person you're the respondent, then don't worry about um, paragraph 6 and paragraph 7. If there are children between you and the respondent, then you have to decide if you are going to ask for custody and visitation and how that is going to look. Legal custody means the important decision-making aspects of raising a child. For example, whether to seek therapy, whether to get braces, whether to go to private school, all of those things are legal custody. So you can ask if you want custody to be only with you, you'll mark the box for petitioner. If you want the respondent to have custody, you'll mark the box for respondent. If you want custody to be shared, then you'll mark the box for joint. The box for other is another box that if you check that one, it's because you had a specific reason. It's not typical to see that box checked. You can accomplish almost all of your goals either by checking petitioner, respondent, or joint. I would stay away from this one unless you have a specific reason. So getting to physical custody, this is the custody of where the child will live most of the time. Again, this can be either with petitioner or with respondent or joint. And again, don't mark the other box unless you know what you're doing because you really probably don't need to do it. Okay, visitation is this schedule of time that the child will be with each parent. So generally speaking, if petitioner has requested physical custody, then the parent who does not have custody will ask for some visitation time. So that would mean that we will mark respondent for visitation. There are several different forms that you can use to ask for specific visiting schedules. These forms are all listed right here, and they all have um, their own specific thing that they are for. For example, this one 312 is to prevent abduction. 311 is for specific scheduling and including who's going to do transportation. Um, you are welcome to use these. If you find this form, these are clickable hyperlinks. It'll take you right to them. Take a look. If you end up using any of these forms, make sure that you check the box on the petition so that the judge knows to look at these forms as part of your case. Okay, child support. In California, there is a guideline calculator. You can find it on the internet if you do a search for California Child Support Guideline Calculator. And if you know the income of the other parent and your income and the time that the child will spend with each of you and some other factors for deductions and some details, it will tell you what the child support order should be. Um, you will have to ask for child support to be ordered. You can also go to the Department of Child Support Services and ask them to start a child support case for you. The cost is minimal. I believe it's somewhere around $25 a year, and they figure out the amount, they collect it, they distribute it to you, they keep track of it, and it's very much easier for them to do it. Okay, next is spousal or domestic partner support. There is not an easy guideline calculation for spousal support. Um, you can, at this point, basically ask for an amount that you think is appropriate. If you do not want spousal support, you can ask the court to terminate spousal support. If you have been married for more than 10 years, you cannot ask the court to terminate it, but you can ask the court to reserve, which just means that if you need it in the future, you can come back and ask. Okay, we are getting towards the end. Hang with me just for a little bit longer. Okay, so in California, we have two concepts of property when it comes to divorce or separation. We have separate property, which is any property that either of you owned before the marriage, since the separation, or that you received as a gift or inheritance during the marriage. If you believe that you have assets like that, and this can be more than just real property. This can be anything from the linens up to the coin collection or anything else. Anything that has some amount of value, you can ask the court to help you divide. So if there is no no separate property, then you can mark box A, and you're done with this part of it. If there is separate property, mark box B, then you have the choice of including it on a form property declaration or an attachment where you're going to just write it out and list everything that you believe is separate property. If there are only a few items, you can just list them right here on the form. So that is separate property, which means the next one is community or quasi-community property. This is everything that was acquired during the marriage with income that was earned during the marriage. Basically, everything that is not separate property is community property, and this should include everything that was acquired during the marriage, including the part of any retirement plan that there were contributions during the marriage. That is now a community asset to some extent. Common in this category would be a house or vehicles or collectibles or other assets. If there is nothing in this category, again, you'll mark box A, and that will take care of that. If there are community assets, you'll mark box B and either do a property declaration, or you could make your own list and write them out. Or if there's only a few items, you can list them right here on the form. I would recommend doing a property declaration, since you will have to do one anyways to satisfy the other disclosure requirements. So this is a good opportunity to go through your list of assets, figure out how much you have already divided with the person you are divorcing versus how much still needs to be divided, and any sort of division that you may want to have. I will be doing a tutorial for this form FL-160, which will go through filling that form out. But in the meantime, I highly recommend doing that at the same time that you do the petition, because you will have to do this form anyways, even if there is no property. Okay, we are almost done here. Number 11 on other requests. If you are doing this all on your own, you do not have an attorney and you are not entitled to attorney fees. Okay. If you would like your last name restored to your maiden name or to the name you had before you got married, then in box 11B, Make sure that you write your full name, first, middle, and maiden name, or else the judgment may end up looking like um, just your last name without any of your other names. So if you would like to switch to a one-named person like Madonna or Prince or Cher, this would be the place you could do that. If you would like to keep all of your names, make sure you include all of your names here with your maiden name instead of your married name. If you have any specific other requests, you can put them here. One example I have seen is for asking that the family dog be shared. It's important to a lot of people, so you could do something like that. If there's anything else that you want the court to order that there was not a box for, write it here. Then type or print your name and sign it. And that is all you have to do for this form. Thank you for sticking with me through all this.